What happens when you speak up at work, whether that means filing an EEOC complaint, reporting discrimination or harassment, challenging unfair treatment, or simply standing up for yourself, and then everything changes? Your schedule shifts, opportunities disappear, the vibe at work, it gets tense. You start wondering, is this really retaliation or just bad timing? This is where a lot of people get stuck, and today's case helps us unpack what retaliation really looks like and how hard it can be to prove, even when you know something isn't right. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. And on this channel, I do more than share legal opinions. I break down real cases to show how the law might apply to your workplace, whether you're an employee trying to protect your rights or an employer trying to do things the right way. One of the biggest challenges employees face, and something I see people struggle with all the time, is trying to figure out whether what happened to them is actually retaliation. And if it is, how to prove it. Most people know when something feels off at work, they know when they've been treated unfairly, but the hard part is connecting the dots. Was it retaliation or just unfortunate timing? That's exactly why I review real cases like this, and that's why they matter. It's also why I created the Employee Retaliation Response Workbook. It's a self-guided tool to help you think through what's happening, organize your thoughts, and recognize the kinds of patterns and actions that often show up in workplace retaliation situations. And if you're trying to understand how retaliation actually plays out at work, I've also put together a playlist of real retaliation cases so you can see how courts handle these situations and what makes or breaks a retaliation claim. You can check out both the workbook and the playlist using the links below. Okay, let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And hey, don't forget to like and subscribe. Kelly Dietrich began working for UPS in 2014 as a preloader in Round Rock, Texas. Over the next few years, she transferred a couple of times, first to California, then back to Texas, settling at the Round Rock location in 2018. As a union employee represented by the Teamsters, Kelly was subject to a collective bargaining agreement, something that would shape nearly every dispute that followed. So back in February 2018, not long after she arrived at the Round Rock, Texas location, a supervisor told her she shouldn't wear tank tops at work. Kelly was offended. She felt that comment was inappropriate, and she reported it to her manager, Mike Lentz. She said that she felt like it was sexual harassment. An investigation followed, but management said her complaint was unfounded. But still, in June 2018, Kelly filed an official charge with the EEOC. Then things escalated. While Kelly's EEOC charge was still pending, another incident happened at work. In September 2018, she got into a heated confrontation with a coworker, and that employee accused Kelly of getting in her face, yelling, and even putting a forearm to the other employee's chest. Other coworkers described Kelly as aggressive, saying she got loud when things didn't go her way. But despite all of this, Kelly won a spot in a competitive driver training program the following month. But there was a catch. In order to pass the program, Kelly had to meet certain requirements. She had to maintain a specific delivery pace, complete her assigned stops, and maintain consistent performance from day to day. Kelly went through the driver program, but according to her trainer, James Shipp, she just didn't meet the requirements. He said she couldn't maintain the delivery pace needed for the job. She missed several package deliveries, and her performance varied a lot from day to day. Shipp reported this to her manager, Paul Phillips, who then removed her from the program. So by November, Kelly was out of the program, so she went back and amended her EEOC charge, adding retaliation to the list of claims. Kelly felt that her removal, it wasn't just about her performance. She was certain that it had to do with the harassment complaint, the the one that she filed earlier. That's why she went back to the EEOC and amended her charge to add a claim for retaliation. She also filed a union grievance, which resulted in a second chance to go through the training program in December 2018. Now, here's where it gets messy. James Shipp, her trainer, he gave Kelly positive feedback during the training. So she believed she passed the program, but by January 2019, Paul Phillips, Kelly's supervisor, he had removed her again, saying she failed to deliver the packages fast enough and missed multiple stops. Kelly later said that her trainer, James Shipp, told her something troubling. That Mike Lentz, remember Mike, he's the manager that Kelly had reported her earlier harassment complaint to. Well, according to Kelly, James Shipp told her that Mike said that Kelly couldn't pass the program. In Kelly's view, that meant that Mike Lentz had already decided the outcome before she even finished the program. So Kelly filed a second grievance, which went before a joint UPS Teamsters panel. The panel heard testimony from both sides and ultimately sided with UPS, barring Kelly from reapplying to the program for a year. Kelly went back to working as a sorter and data entry clerk, but workplace tensions didn't end there. In April 2019, she had a verbal altercation with a security guard. UPS planned to suspend her, but she went out on FMLA leave of absence after the altercation with the security guard. When Kelly returned from 6 weeks of FMLA leave in June 2019, UPS handed her a notice of intent to suspend her for a verbal altercation with that security guard. Less than a week later, there were 2 more reports from coworkers. In the first, another employee said Kelly became angry when that employee, not Kelly, but that employee was asked to move packages from one station to another. The coworker said she felt threatened by Kelly's reaction to what she was asked to do. That same day, another employee reported similar behavior. UPS responded by issuing a notice of intent to discharge Kelly on top of the suspension notice she had just received. Kelly challenged both actions through the union grievance process, and in the end, the union, they reduced the suspension to a final warning and the discharge notice to a 30-day unpaid suspension. While serving that 30-day unpaid suspension, Kelly filed another EEOC charge. She claimed that the suspension wasn't really about the altercation with the security guard or the 2 coworker complaints. She believed that they were picking on her and she was being paid back for speaking up in the past. In her view, UPS was retaliating against her for her February 2018 sexual harassment complaint, her first EEOC charge, and the union grievances she filed after being removed from the driver training program. Those grievances moved through the union process over the next several months, and UPS didn't put Kelly back in the training program. But she did continue working at UPS in other positions. Toward the end of 2019, UPS made Kelly a full-time combination delivery driver. That's a hybrid role where you mostly deliver packages, but you can also be assigned warehouse work. She could be at the warehouse one day and a delivery driver the next. In April and May 2020, Kelly, who is Black, alleged that her supervisor gave better routes to white employees with less seniority. But the record showed that some of those employees didn't even work those days or were only part-time and couldn't take certain routes. After returning from a second leave of absence, Kelly said her new manager assigned her to heavy packages, some of which were up to 150 pounds, even though her manager knew about her past injuries. So she filed yet another grievance, accusing her manager of harassment, racism, and retaliation. She returned to driving. She requested a specific route. She asked for help delivering packages, and 2 drivers came to assist. With technical issues, including a dying phone and scanner, she ended the day with 73 undelivered packages. 3 days later, she received a notice of discharge, this time for falsifying delivery records. UPS said the issue wasn't just the 73 undelivered packages. According to the company, Kelly's delivery records for that day didn't match the actual status of the packages. And in their eyes, that wasn't simply a mistake, it was falsifying delivery records, a dischargeable offense under company policy. She filed yet another grievance, and in September 2021, the union upheld her termination. And then Kelly sued UPS, claiming retaliation for her EEOC complaint back in 2018, racial discrimination in route assignments, and retaliatory termination. So, how did UPS respond to Kelly Dietrich's claims? Well, they said that Kelly was kicked out of the driver training program for performance issues, not retaliation. And they also argued that the managers who made that decision didn't even know about her EEOC complaint at the time. UPS also said the route assignments Kelly complained about were made for legitimate business reasons, that they were assigned based on package volume, driver coverage, and seniority. And UPS also said that her termination was tied to discipline and disqualification from the driving program, not retaliation. They basically said she broke company rules and they followed their policy. And the court sided with UPS. A federal magistrate judge granted summary judgment, and that basically means the case didn't have enough evidence to move forward to trial. And the court said that Dietrich did not argue that James Shipp or Paul Phillips knew about her sexual harassment complaints. Dietrich actually admitted in her deposition that she had no evidence that either manager knew about her complaints. So the court said Dietrich basically failed to prove that the actions taken against her were the result of the discrimination claims she filed. Let's take a minute to talk about why the court said that this wasn't retaliation under Title VII. To prove retaliation, the first thing you have to show is that the person who took action against you, like kicking you out of a training program, which is what we saw in this case today, you have to show that they knew you made a complaint. That's a key fact. If they didn't know, there's no way that they could retaliate. In Kelly's case, there was no evidence that the manager she complained to, Mike Lentz, that he was the one who decided whether she passed or failed the training program. There was a vague comment allegedly made by Lentz. The court said it wasn't clear enough to prove he made the call or that he did it to punish her. Then there's the second issue, the people who did make the decision. There was no indication they even knew she had filed a complaint or an EEOC charge. And if they didn't know, then legally, they couldn't have been retaliating against her. That's what the court said. No knowledge, no retaliation. This case is a great reminder that even though filing a complaint is protected, it doesn't guarantee success in court. You still need clear evidence that it was your complaint that caused the action taken against you. When retaliation or discrimination is claimed, the court is going to look closely at timing, documentation, and whether decision makers knew about the protected activity. Kelly Dietrich's case is one of perseverance, but also of how incredibly high the legal bar can be when you're trying to prove retaliation or discrimination at work. If you don't have the evidence, if you can't show that the people making the decision knew about your complaint or that their actions were because of it, you're probably not getting very far in court. So, if you found this story insightful, please give it a like and subscribe to the HR Insider. If you want to learn how to protect yourself from retaliation, check out the Retaliation Workbook linked below. It's a self-guided tool that helps you document, reflect, and respond with structure and confidence. I'm Harlow Reed. Thanks for watching today, and I'll see you in the next video.